Okay, good morning, everyone, and welcome to today's webinar titled Examining Kenya's GI Bill 2026. My name is Dr. Melissa Omino, and I'm the director of CIPIT, which is a Center for Intellectual Property and Information Technology Law at Strathmore University, and I will be moderating this session today. I am joined by a panel of two discussants who are here with us. Our first discussant is Chebet Chorus, who is the research fellow in charge of intellectual property here at CIPIT, and my senior, Mr. Manasseh Mwangi, who is the managing partner at MAS Associates and Advocates. And this webinar is brought to you as well by IP Check-in. So we thank you so much for joining us. So we'll start with a background and framing, which I will do, as well as an introduction to the bill on part 1 and part 2. I will then be followed by Chabet, who will present on parts 3 and part 6. And finally, Mwangi will join us for part 4 and part 5. There'll be a moderated discussion with both discussants and a Q&A portion opened up for you, our guests, and hopefully we will close by 12 noon. A quick note on the format is that we are setting the scene with the short background based on part 1 and part 2 of the bill. We won't have an in-depth discussion there. We've really isolated the in-depth discussions for parts 3, 4, 5, and 6, and I hope you'll understand why we are doing that. So, why this bill and why now? A geographical indication, in plain terms, is a sign used on products that come from a specific place and that owe their quality, reputation, or other characteristics to that place. A good example in terms of a global understanding is champagne, which comes from the Champagne region in France. But Kenya is not left behind. We have Kenyan tea, we have Kenyan coffee, and we even have Kisii soapstone as commonly cited Kenyan candidates, especially in the policy literature. Two reasons geographical indications or GIs matter for Kenya. First is value capture. When a product's reputation is tied to its origin, producers can command premium prices, but only if the origin link is legally protected and enforceable, both at home and in export markets. Secondly, identity and culture. GIs are one of the few tools that protect collective place-based knowledge and practices, which makes them a useful complement to traditional knowledge frameworks. On that point, it's worth noting that the bill's clause 2 definition of indication expressly includes traditional designation, which gives the traditional knowledge interface a textual hook in the statute itself, or the proposed statute. Kenya's path to a standalone GI law has been long, with predecessor versions in 2007, in 2015, and in the 2020 Consolidated IP Bill, as well as in 2024, a reiteration of a GI bill, leading us here today to the 2026 iteration that we are looking at. Two framing observations. First, until this bill is enacted, GIs in Kenya are protected mainly through certification marks under the Trademarks Act, which is not a true GI regime. Second, Kenya's TRIPS obligations under Articles 22 to 24 already require a baseline of GI protection. So this bill is partly a long overdue compliance step and partly a strategic instrument to actively register and defend Kenyan origin products. With that framing, I want to walk you through parts 1 and 2, which set up the infrastructural architecture before we move into substance. There are 3 things to flag when you look at the preliminary clauses of the bill. First, the definition of geographical indication in clause 2 tracks with the TRIPS Article 22 with one notable difference. TRIPS uses essentially attributable, and the bill says exclusively or essentially attributable. And that is a slightly more permissive threshold for applicants and is worth keeping in mind. Second, the object clause in clause 3 is notably broad. It covers a legal and institutional mechanism, prevention of usurpation and misappropriation of Kenya's unique products, and consumer protection from deception. The middle limb signals that this bill is intended to do offensive as well as defensive work. The word usurpation is common in EU GI instruments, so this language has a comparative lineage, not copy-paste, comparative. Third, the application clause in clause 4 explicitly lists county governments alongside the national government, both registrars and enforcement agencies. That is a policy choice that has consequences, but it's something that we are seeing in other policy documents that touch on the intellectual property regime. This is because of the bottom-up, I guess, policies of the current government, but also ensures that we are really implementing the devolution of government. Now, in part 2, coordination and oversight. This is covered in clauses 5 to 10, and the institutional design rests on 3 pillars. The cabinet secretary responsible for industrial property gives policy direction, oversees the act, coordinates international obligations, and formulates a national geographical indications strategy under clause 5D. The bill contemplates this strategy in primary legislation, but does not specify a timeline or content requirements, which is something that we all need to track post-enactment of the bill, should it be successful. The Registrar of Geographical Indications under Clause 7 is the Managing Director of the Kenya Industrial Property Institute, and the bill anchors GI administration inside existing KIPI structures rather than creating a new authority. And this is efficient in implementation terms, but raises capacity and culture fit questions. Since GIs are collective and place-based, meaning location-based, whereas the rest of KIPI's caseload is largely individual rights holder driven. That last point is my reading. That's not what the bill actually says, but it is the implementation question that we need to ask ourselves. County governments are given a substantive role under Clause 6, as I've mentioned before, that there are roles for both national and county governments, including mobilizing producers, supporting registration of cooperatives and associations as legal persons, confirming the delimitation of the geographical area, ensuring environmental conservation measures, and maintaining a county-level repository. IP is not in the 4th schedule as a county function, but agriculture, county planning, and trade development are. So the bill builds the county role on those constitutional anchors. Whether counties are resourced and skilled to play this role is the live implementation question that we will ask. Now that I have presented the basic architecture that is within this bill, I'd like to hand over to Chebet for the substance of protection in parts 3 and parts 6. After that, we will go on to Mangi on parts 4 and 5, and then I'll come back to bring forth a discussion. So over to you, Chebet.
Thank you very much, Dr. Melissa. I'll go straight ahead and talk about section 11 through to section 13, which is in part 3. So starting with section 11, this talks about protection regardless of registration. And this is an important policy choice because it provides that geographical indications are protected whether they're registered or they're not. And this is especially important for Kenya, where we have producer communities that may lack the institutional capacity to pursue formal registration. I'll give you a case example. This is the Tinderet case, where the absence of a dedicated GI framework resulted in inconsistencies in registration for enforcement. So in the Tinderet case, This was where there was an attempt to expunge the trademark Tinderet tea farm, but despite evidence that showed that Tinderet, which is an area in Kapsabet where there's tea that is grown there, despite that evidence that there is unique geographical conditions which contribute to the distinct quality of its tea, the case for expungement was not allowed by the TP tribunal. And this highlighted several issues, which one of them was that the lack of a legal definition for GIs in Kenya has caused trouble. The reliance of trademark law, which does not adequately capture the communal nature of GIs, is also an issue that came up, and the reluctance of the bodies to recognize GIs beyond trademarks. So it's important that we're having this GI bill. And it shows that small-scale farmers struggle to navigate the trademark system, and so the GI bill can actually come and help that. And Section 11, in practice, would allow for producers of products such as traditional agricultural crafts, goods, to be able to protect themselves even before completing the registration. So it also extends protection against misleading uses, including situations where designation is literally true, but falsely suggests a different place of origin. So for example, if you cannot label a product in a way, rather you cannot label a product in a way that suggests it comes from a well-known region when it comes from somewhere else, even if the label is technically true, but about where it's originated. So that's still in Section 11. However, the practical impact of this provision is weakened by broader structure of the bill. And Mwangi will talk more about this, but I'll just highlight it. So Section 11 recognizes the protection without registration, but Section 36 of the bill provides that there's no proceedings that shall be instituted to prevent or to recover damages for the infringement of an unregistered geographical indication. Section 37 goes on to say that passing off action and remedies around passing off action are going to apply. So this creates uncertainty about how unregistered rights actually can be enforced. And this risks rendering unregistered protection largely symbolic. Additionally, the civil proceedings available under Section 30 do not clarify if this actually applies to unregistered GIs. It doesn't clarify who may bring the claims for unregistered GIs, what evidentiary threshold is required, and what remedies would be available for unregistered GIs. So this makes, or rather it creates difficulties, or is likely to create difficulties for the courts and enforcement agencies. My recommendation for improvement here would be to clarify the unregistered GI that are enforceable through civil proceedings. Another recommendation is to define the evidentiary threshold for proving an unregistered GI, and this would include reputation and geographic linkage. Thirdly, would be to clarify the standing, which would mean that it would allow producer groups or competent authorities to initiate proceedings under this section. Then I'll move on to Section 12, which talks about the homonymous geographical indications, which means indications that share the same name but originate from different locations. The provision allows both indications to be protected, subject to differentiation determined by the registrar. And this approach is consistent with international practice and particularly useful for us in Kenya, where there may be shared names with neighboring foreign locations or where multiple localities within Kenya use a similar names. But the provision also, as it grants a broad discretion to the registrar without providing statutory guidance on how differentiation should actually occur. So it doesn't specify labeling requirements, geographical qualifiers, what the coexistence conditions would be, and any priority rules that should be there. And this can lead to inconsistent decision-making and also legal uncertainty for the producers. So for this section, my recommendation would be to specify what the differentiation mechanisms are, such as the geographical qualifiers or labeling requirements. Also to introduce criteria for determining the coexistence. This could include reputation or prior use. Then thirdly is to require consultation with the affected producer groups. And lastly, to provide for publication and possible opposition to differentiation decisions. This measure would help. The measures that I have proposed would help to improve transparency and predictability in managing the homonymous indications. Moving on to Section 13, which provides for exclusion from protection. It sets out the grounds for exclusion for protection. And this include indications that are offensive, contrary to public interest, generic, misleading, or conflicting with trademarks, plant varieties, or animal breeds. And this provision plays an important protective role, but the grounds that are provided here are overly broad and they may undermine the protection that is being offered. So first, the reference to indications that are undesirable under subsection 1A is vague and could allow subjective refusals. Secondly, the public interest clause under subsection 1B is particularly expansive, including national security, nutrition, environmental conservation, and development of other sectors of the economy. So these objectives are important, but then their inclusion as absolute grounds for refusal may create uncertainty and discourage applications. Under subsection 1F, which excludes indications similar or identical to known marks, this lacks clarity regarding whether this refers to earlier trademarks, well-known marks, or likelihood of confusion. Finally, the environmental conservation requirement under subsection 2 is, while it's innovative, it's very somewhat unclear. It requires applicants to include environmental conservation measures, but the bill does not specify the standards or enforcement mechanisms of the same. So my recommendations here would be to narrow the public interest clause to public order or morality. And then secondly is to clarify the relationship between GIs and earlier trademarks. And then the subsection 2 on environmental obligations, my recommendation is that this is more move towards the registration criteria, which will be discussed later, rather than it being under this section of inclusion grounds. Then when we move on to part 6, which talks about special provisions concerning marks and names, the provisions address the interaction between geographical indications and trademarks. And section 32 talks about deceptive or confusing marks, which allows refusal or invalidation of trademarks that contain geographical indications for goods not originating from the located region. This provision helps to prevent consumer deception. However, the provision is rather reactive rather than proactive because the registrar may act only upon the request of an interested party. And this places the burden on producers who may lack the resources to monitor trademark applications. So for this, my recommendation would be to allow the registrar to refuse misleading marks on their own as ex officio. Clarify the coexisting rules where trademarks predate GIs is also an important recommendation that we have. And then section 33 talks about the exceptions regarding prior users. So it permits the continued use of trademarks identical or similar to registered GIs, provided they were used in good faith. And this protects existing businesses and promotes legal certainty. However, the provision is broad and may undermine GI protection. So it does not define what good faith is. It does not impose the limits or address consumer confusion. And as it is drafted, it could also allow indefinite coexistence within even where the GI's reputation is harmed. The recommendations here are to provide better definitions, so define what good faith is and require prior use before GI registration, permit coexistence subject to conditions such as labeling, and to introduce the transitional limitations that should be there. Lastly, I'll talk about section 34, which is the use of names in the course of trade. So this is a standard safeguard that's intended to protect legitimate commercial use. However, there's need for additional clarity because the provision may be used to circumvent GI protection. For example, if a business is outside the geographical area, it could rely on company names that evoke protected regions. So simply here, the recommendation is to provide clarity by limiting the exception to honest commercial practices, to prohibit use that takes unfair advantage of GI's reputation, and to clarify the exception, that the exception does not permit misleading trademark use. So with that, I will hand it over to Mwangi to handle the rest of the section. Thank you.
Thank you very much, Chebet, for that able representation. The law on GI and the best way to discuss it is from a scheme level because this is a very general bill that we have struggled with since 2007. I think we have had over 5 bills in an attempt to enact a GI bill. But the question would be, have we gotten it right? First of all, I would like to congratulate all of us as a country for making that bold step to eventually accelerate having this bill after a long struggle and many efforts to achieve at least the level we have gone thus far. The bill is still at a public participation level and it has gone to Parliament. We hope to get another opportunity. And because we need to submit comments, we had very limited scope of time and space to discuss the bill. I would like, first of all, to discuss it from a general scheme of the Act. Geographical indications are in two general classes. They are the geographical indications that specifically mention the name of the geographical location that they come from. And there are other geographical indication products or marks that do not mention the name of the place where they come from. For instance, when we talk about basmati rice, which is a geographical indication in Pakistan and India, basmati is not a name of a particular geographical address. But when we talk of Scotch whiskey, that has a direct reference to the geographical origin of that particular product. So in order to have a broad and a sufficient coverage of the right envisaged to be protected by this nature of rights, there are two types of marks that should always be envisaged in a bill of this kind. One is a geographical indications mark, and two is an appellation of origin. And the scheme of our Act do not seem to have envisaged an appellation of origin. How that would be more clearer is how by looking at, for instance, coffee and tea, because those are the most basic geographical indication products that maybe would be the first ones to be protected. When you're in the world market, we talk about Kenya tea or Kenya coffee. When you come home, we have Kericho tea, and we have Nadi tea, and we have Murang'a tea, or the Mount Kenya tea. And similarly for coffee. Domestically, you're going to have geographical indications for all those coffees. But when you go out there, they may not be recognizable. They will only be known as Kenyan tea and Kenyan coffee. We should be able to have an appellation of origin potentially managed or administered by the government of Kenya or the Ministry of Agriculture or the relevant authorities like KTDA and CBK to protect Kenya coffee as a product originating from Kenya. Whereas we have geographical indications like Kericho tea or Nadi tea that are managed by the particular groups. So that is one shortcoming of this bill that we may need to look at. Going on to registration, and I like the way the bill has really tabulated and attempted to even give the considerations that should be considered before a geographical indication is registered or is considered qualified for registration. One shortcoming I have found with the bill, which Chebet has mentioned, is requiring that geographical indications can be protected in Kenya, even if they're not registered. Unlike copyright, trademarks and geographical indications, as well as patents, they cannot confer rights on any individual before registration. Copyright abhors formality, but without formality, you cannot acquire trademark rights or geographical indications rights or patent rights, with, of course, important exceptions for trademarks. When you say that you can protect a GI that is not registered in Kenya, and it happens to be a foreign GI, that presents major difficulties because the registrar may not be able to ascertain whether in the country of origin that GI complies with the regulations or the technical file for the maintenance of that GI in the country of origin. Two, that would be discriminatory because you are requiring protection of foreign GIs without registration, but it is uncertain whether a similar benefit will be afforded to Kenyan geographical indications. When you look at the TRIPS agreement and the Lisbon agreement, the obligation of the member states is only in providing a mechanism for protection of geographical indications. There is no requirement to protect a geographical indication that has not been registered. So I think in requiring protection of geographical indications that are not registered, this amounts to legislative or parliamentary overreach, and it should not proceed as such. My recommendation would be to let the owners of such geographical indications or who consider their marks geographical indications to protect them in similar provisions as those in Section 5 of the Trademarks Act if they can be able to prove goodwill or reputation, and they can be able to prove knowledge within the jurisdiction of Kenya, then they should be allowed to protect from those circumstances. And that will not be the province of the Registrar of Geographical Indications. That can only be the province of a court as defined by the Act, and the Act defines the court to mean the High Court. This is because we will require to receive evidence of one, well-knownness, and evidence of goodwill or evidence of reputation. The other problem we have with that provision is that before the decision of the Court of Appeal in the Basimati case, we did not know what is the status of the unregistered marks, geographical indications. But the Basimati case was very clear. The Court of Appeal indicated without registration, one cannot claim protection of geographical indications in Kenya. So in proposing protection of non-registered geographical indications in Kenya, I think the Parliament will be entering an alien territory. One, it risks violating the doctrine of separation of powers. It risks violating the doctrine of judicial independence, and it looks as though it is an attempt to legislate against a judicial decision. I think we may have required more policy guidelines or a better policy rationale in order for us to have such a provision. The other problem we are going to have with the protection of unregistered geographical indications is in enforcing the particular provisions on annulling of a geographical indication. If there was no basis for which that geographical indication was protected in Kenya, for instance, the requirement of regulations or rules or having a technical file, then the Registrar of Trademarks may not have a basis for which to measure whether that geographical indication should be annulled or should be maintained on the register. Moving on to the role of the counties, Section 15 of the bill has given the counties a role to approve before a geographical indication is registered. We have a challenge with that because one of the reasons or one of the factors that are considered in registering a geographical indication and in developing the regulations and also the technical file is the climatic conditions and the particular circumstances like the conditions of the soils that affect the outcome of the product of that particular region and influence the quality. So do we know whether the county has mapped up its own soils and the various regions as to the climate, amount of rainfall, the sunshine, the durations of sunshine, and also the kind of soils obtaining in the various regions? for us to be able to bestow the county with this obligation. I think we have specific authorities that are entitled or that have a specific statutory mandate to deal with those conditions. One is the Meteorological Department. Then we have authorities like KTDA and CBK, Coffee Board of Kenya, that are able to ascertain those conditions. The ability of those authorities to ascertain those conditions was underpinned by the Registrar of Trademarks in the matter of the T Farms case. It was a trademark case that was challenged on the basis that the George Williamson Tea Company had applied to register a geographical indication as a trademark and to appropriate it individually to the exclusion of the rest of the community. And among the observations that were made is that KTDA had actually mapped up the climatic conditions obtaining in many tea growing areas, including the altitude levels. If we were to subject experts to counties, then we'll have an unnecessary bottleneck. And I think the role of the counties should be limited to having a repository of the geographical indications. The only place where the county may have some level of approval is in respect to those geographical indications that address issues of traditional knowledge and traditional cultural expressions, because culture and the traditional knowledge is a devolution matter under the Constitution, and maybe it's only the counties themselves that can talk about the culture of that particular community. The other challenge we have in giving such a sweeping mandate on the counties, we'll have a problem when we have trans-county geographical indications. We have one geographical indications registered in Kenya under the Trademarks Act, which is the Taita baskets. And the Taita baskets, as a geographical indication, is indicated to cover 3 particular counties: the Taita Taveta County, Kilifi County, and Kwale County. If we require approval for registration of that geographical indications, then which county is supposed to give that approval? I think we should remove approvals from the counties and instead give them the mandate to maintain a repository of those county geographical indications. I know that my time is running out, but just allow me make a comment and say that the counties would have another final mandate in administration of trans-county geographical indications. And what we should be having is a provision to cover geographical indications that transcend counties. And they should be given a joint mandate to administer those geographical indications. And we need to have a dispute resolution mechanism for resolving those trans-county geographical indication disputes. Finally, on honominous geographical indications, we have a problem. And in the Basmati case, this problem came out very openly. We had a proprietor from Pakistan who had owned a mark in Kenya, but the Indian proprietor was contesting the Basmati mark. Eventually, we could not resolve that dispute, even from the embassies. And I wish we had one of the persons who had handled that dispute, Karo Mushiri or Perpetual Mwangi. They would have told us what responses they got from the embassies. Again, when we have, and there are so many geographical indications that cut across even national boundaries, when we have such disputes, how are they going to be administered under this new act? There's no proposal. The final appeal on determination of geographical indications. Again, in many countries and in many instances, the final appeal rests with the World Trade Organization. And we have a dispute resolution mechanism at the WTO. We do not have a reference, and we seem to suggest in our bill that the last point of appeal should be our highest court in the hierarchy of courts in this country. I think we also need to have a look at that mechanism of dispute resolution especially where the geographical indications are foreign. I'll pause at that. I'll have an occasion to revisit the other areas. Back to you, Chair.
Thank you. Thank you so much, Mwangi, for taking us through. And I do like that you focused on particular clauses. I do have a question already from the audience. And because this is meant to be for the wider IP checking community and anyone else who's interested in geographical indications, please allow me to ask the question. The question is, given that geographical indications require clear traceability of origin, how should insurers assess the risk where products are blended but marketed as single origin, potentially leading to misrepresentation claims from competitors and disputes with buyers?
Thank you very much. There are two types of geographical indications. Again, there are the crafted geographical indications, and then we have the agricultural geographical indications. The agricultural geographical indication products are sold as they are harvested or processed naturally. They are not blended or mixed with other additives. On the other hand, the crafted products, and this, I think, what easily comes to mind is whiskies. We have whiskies or brandy or cognacs. For the insurer, how to ascertain traceability and quality? You have to make reference to one, the technical file, because for whiskies like Scotch Whisky Association or cognac, they have a technical file that clearly stipulates if you are blending, the extent to which you can blend. And if you're adding sugar, the extent to which you can add caramel. And you must be, you are also required to clearly set out how you have blended your particular product. So for the insurer, to ensure traceability, one, you must refer to the technical file and you must refer to the recipe of the particular drink, which you can be able to ask from the developer. If you are able to ascertain that the owner of the geographical indication product is not telling the truth, that can be one reason to invalidate that geographical indication. Or two, if he's a member of a big organization, to ask for their removal from that association and to be stopped from using that particular mark. I think that's how I would like to address that issue. But George's question ties down to another particular problem presented in the bill. In one of the sections, the bill says that you cannot mortgage or pledge or enter into financial transactions based on this mark. Madam Chair, do we address that now? Can we revisit it later?
Yes, please do address it.
Yeah. So it raises an interesting question because George is talking about insurance, and insurance is basically a commercial transaction. And many people insure their products for many things, including losses or other risks. So when the bill particularly and explicitly says that you cannot enter into a commercial transaction using that particular geographical indication, I think that's an affront and enable on the commercial development of the industry. And it is an express violation, one, of the Constitution, Article 50, on the right to property. You should be able to commercialize your intellectual property right the way you wish, whether individually or in association with others. I think the parliament should allow the owners of the geographical indication individually or in association with the others to decide how they are going to commercialize, to what extent, and what benefits that such commercial transaction should bring to each individual. The other violation that we are seeing in this bill is this bill is violating the Movable Securities Act, because the Movable Securities Act clearly stipulates the kind of movable securities that can be pledged as security. Intellectual property rights is one of them, and GI is an intellectual property right. So I think on those two fronts, I think the safest recommendations I would prefer, if Parliament is not certain about this commercialization, they should just allow it to remain silent and wait for the industry to develop, and then the law will play catch up as it has always traditionally done.
Thank you so much, Mangi. I don't know about making the law remain silent, because then you will say that there's a lacuna in the law, as we always say. But yes, it's very interesting that they've put that provision there. And I wonder what the thinking behind prohibiting pledging and mortgaging GIs is. Perhaps it's around the collective nature of GIs. Remember, these are not meant to be individual based rights, they're communal rights, and there are still questions around how do we ensure access benefit sharing of communal rights. So perhaps the lacuna in the law is the framework to ensure that access benefit sharing trickles down to the community. But this is me imposing myself in the discussion. I want to now move back to Chebet. And I know that Chebet has a few things to say about Part 6, especially around Clause 33 or Section 33, whatever. We're calling them clauses because this is still a bill, not yet an act. So Clause 33 talks about preservation of good faith prior trademark use. And is there a risk of dilution, especially for products where domestic trademark predate any GI registration? Chebet, over to you on that.
Thanks for that question. So as I mentioned before, Clause 33 provides that there can be use in good faith of a trademark that's identical or similar to a registered GI, and that this can continue. So it's a standard safeguard because the GI regime has to also protect the legitimate earlier trademark rights that are there. And the provision, but then this provision as it is, it might significantly dilute GI protection in practice, particularly for the Kenyan products, which have historically been commercialized through trademarks. If you think about an example like Kericho Gold or Sotik Tea, these are tea brands that are already well known in Kenya and even outside Kenya. But so if these trademarks predate GI registration, Clause 33 would allow them to continue definitely, even after this GI registration. And this can lead to coexistence between the GI and confusing trademarks. It can cause confusion within the ecosystem. It can also weaken the collective nature of the GI, which can lead to dilution. It can also reduce the exclusivity for producers in the geographical area, and consumer confusion may be, broadened. So it's particularly high where the prior trademark uses the same geographic name. So for example, if you think about Kericho Gold Tea, the geographical area of Kericho is where a lot of tea is produced. So what does that mean then for all other farmers who are within that geographical region? There's likely to be confusion around that area. Another high risk is where the trademark owner is outside the GI area. I'll give everybody who's listening some homework, go and figure out one of the bigger tea brands in Kenya. Who owns it? Is it a subsidiary of a UK company located in London? I'll just leave it at that. You can find out. But this is also some of the risks that are brought out where the owner is outside the GI area. And what does this bill talk about that? Then the trademark also the trademark has strong market presence. This is also another risky area. So Clause 33 does not define what good faith is. It does not also require absence of consumer confusion. It does not impose any conditions such as labeling or limiting the geographical scope. So essentially, it can create a very broad carve-out of GI protection. And this means that the GI that is registered cannot displace the existing trademark. If we can think about a more balanced scenario that can maybe not create too much of a dilution, it would be where there's some allowance as to the continued use, but then there's some parameters to this. For example, qualifiers, limitations as to the use, and restriction of expansion of the earlier trademark that is there. And of course, we need a clear definition of what good faith means. Yes, that's my opinion.
I could see that Mwangi was really raring to say something as you are speaking. Mwangi, I want you to answer the same question about predated trademarks and dilution based on these provisions of the GI Bill. But there's also a question that George asked, which ties to what Chebet was asking us about the registration of some of these trademarks that have, geographical, well, location indications. And he asks, does processing or manufacturing confer any origin rights, or would the use of a GI-linked name in such circumstances constitute an intellectual property infringement, thereby triggering liability exposure? And Mangi, I'm asking you this because I think you have a lot to say around that.
In respect to what Chebet has just talked about, bad faith. Bad faith, even in trademark practice, after the recent decision of the Supreme Court of the United Kingdom, it's a whole basis area on what is a bad faith, what can constitute a bad faith, or what does not constitute bad faith. But I think the bigger problem we have from this bill is not with the practitioners or the owners of the IP rights, but it is with the registrar of geographical indications and the registrar of trademarks. One is because the bill does not indicate how the names that reference geographical indications are going to be treated in light of this bill, or how they are going to be transitioned, or whether there will be a mandatory process of transitioning. If, for instance, geographical indications are supposed to be owned communally, so that there's no single individual who can own a geographical indications. What happens to the individuals who already have trademarks that reference to geographical indication and geographical origin products? Two, what happens to the certification marks under the Trademarks Act? Because we must choose one or the other of the systems. America uses the trademark system of registration of GIs. Europe uses a sui generis law. Now we are transitioning from trademark system to a sui generis law. What happens to the rights that were protected under the Trademarks Act? There is no creation of a clear transition plan, which must be a mandatory plan, or whether those rights are going to be retained under the Trademarks Act. One of those case studies, again, I go back to the Tideret Tea Farms trademark case. This was trademark number 100387 by George Williams Tea. In that decision, the Registrar of Trademarks ordered Williamson Tea to return their certificate of registration of trademarks Tideret Farm and required a disclaimer to be required on the certificate. And it was actually imposed that one, they're only going to use that trademark in respect to tea originating from Tideret. And when you look at the other two conditions, the Registrar of Trademarks seemed to have had a geographical indication mark in mind. So in essence, that trademark is a geographical indications looking at the disclaimers imposed on that certificate. So are we going to have that trademark transitioned into a geographical indication mandatorily? Two, are we going to require that Tideret Tea Farm to surrender that trademark to an administrator as envisaged under this law? And three, in a trademark like Tideret Tea Farms, where there was already a challenge during its registration or subsequent to its registration, if someone else comes to try and register, would you say that the Tideret Tea Farms is maintained on the register by good faith? Or can you infer bad faith, where there are already conflicts that were arising during registration? The other problem we will have is when you talk about bad faith, and this happens with many foreign traders, they ignore Kenya or Africa as a market. Then 10, 20 years later, they realize actually there's a big market in Africa. Let's go to Africa. When they come to Africa, they find actually someone else is using that as a trademark or as a GI. And they start saying, no, it's bad faith because we used to use this one way before. Again, we should require an enforcement record. We should require an enforcement record as a ground for us to infer bad faith. We must be able to tell this particular trader has made every effort to enforce their trademark or their GI, and this should not be allowed to be violated in Kenya. Otherwise, when someone else acquires a trademark or a geographical indication rights in Kenya, and it may seem as though they are violating a foreign geographical indications, how is a register of trademarks going to assess that? Should we move from the point of, first of all, assessing bad faith or good faith? Or should we, first of all, move from the point of assessing even the person who is violating the GI? Have they acquired any rights? Because to acquire goodwill, you must have spent so much money to advertise, to promote the brand. You have a clientele, you have a market share. Can you take away a geographical indication from someone who already have a market share and has built goodwill, even if it's supposed to be violating a foreign trademark? Again, the Act has not addressed those kinds of instances. Uh, on what George is
Mangi,
asking, yes.
Mangi, before that, we have 5 minutes. So I want us to get to one overarching question that I had for both of you. Mangi, I can sort of tell there's a hint about where you're heading with regards to the one thing you would want addressed before the bill gets to Parliament. So I'm going to ask you that question. And are you going to stick towards the question around dilution of trademarks, or are you going to stick with the question of unregistered GIs having protection under the bill? I'm directing you to sort of pick there. And then, Chebet, also for you, what is one thing you would wish would be changed in the bill before it approaches Parliament? And I'll give each one of you a minute and a minute each. Mwangi, can ladies go first so that Chebet has an opportunity? As I know you're combining your answer as you're picking something else that George has asked. Thank you.
I was actually afraid you're going to put me into a conflict.
I'll give Mwangi more of my time. I'll be very brief. For me, one thing is definitely on Section 11 and enforceability of unregistered GIs. There just needs to be clarification on how that works, because without that, we just have challenges in court. There'll be a lot of, confusion. And so if there can be some more clarification on whether Section 36 specifically, Section 30 about enforcement, can apply to unregistered GIs, that I think would help the bill's functionality. I'll yield my time to Mwangi.
Thank you, Chebet. Remember, all these people will be in KIPI. KIPI also handles trademarks, right? So we'll have a GI registrar under KIPI. Should that person be intimately acquainted with the trademark registrar, or should it actually be the trademark registrar / GI registrar? Over to you, Mangi.
Moving from where you've just left in the same breath, the GI bill makes the registrar of trademarks the same registrar of GI, because the managing director of KIPI is both the registrar of GI and the registrar of trademarks. There is one institution under the KIPI that should be rethought, the trademark examiners, and now the geographical indications examiners. Many of times we challenge the registrar of trademarks, but actually the decisions are made by the examiners and the assistant registrars. So I think we need to rethink that mandate, and also we need to overhaul our manual or mechanisms for assessing examination of trademarks. One thing I would like changed before the bill goes to Parliament: remove strictures on securitization of geographical indications. If you are saying we do not know how those communities are going to deal with their own money, cooperatives are already taking loans using their goats and cows and their land and their houses. How do you say that in respect to money coming from geographical indications bill, they don't know how to go about it? You can make it very clear, and that's also the other problem we have in the bill. The bill says persons can register geographical indications. It is not very clear whether these persons must be acting communally or must be a body of associated persons. So it creates a lacuna where even an individual like myself, if I own 4,000 acres of of grapes in Naivasha, I can decide that I want a geographical indications mark for all my grapes in Naivasha because there's no any other person who is farming grapes in Naivasha. I'm the only person. Why should I be denied that right? So I think that needs to be rethought. But I also agree with Chebet. Do not allow protection of unregistered geographical indications. Let those disputes come. We resolve them when they come. Again, we must secure our work.
Okay, Mwangi has put his cards on the table. George, unfortunately, we've run out of time. It's 12 noon and it's in the middle of a Monday, which is a working day. So we need to release people to go back to work. But this is just a highlight of what came out as discussion points on the Geographical Indications Bill of 2026, which has been predated by 5 other versions of GI legislation. So thank you so much for joining us. I want to thank our discussants, Chebet Koros and my senior, Mwangi Manasseh, for joining us today. Asanteni sana. We will be sharing the recording to those of you who have attended. And if you feel like we should have another discussion on this, I think a podcast would be a good way to go. We would have much more time if you can secure the time of